All right, Jim, let's welcome our viewers to episode 2 of the Trial Time Podcast. Today's topic is how do you prepare for trial? So, Jim, you've tried hundreds of cases.
Yep.
How do you prepare for trial?
Oh my goodness. You're asking a large question in a short period of time. So let's see what we can do with it.
Okay.
Well, the first thing you have to do, in my opinion, is you start off with your client. You find out and let them tell you what their story is about what happened. Okay. The next thing you do is you want to know if there are any witnesses available to this. And they'll, your client may know some, may not. But if he does, you talk to them. Next thing you do is you want to get discovery from the government. So you get that no matter how big or how small, you've got to go through every page. Now, here's the trick to it. Okay. The trick is not necessarily what you're looking for, but also what's not in there. So, for example, you're looking for contradictions in the evidence from witness to witness. You're trying to find out where the mistakes are that the police made, or maybe not even how thorough they were. So a lot of times what you're looking for is what you're not looking for. So for example, if it involves forensic evidence, you want to look and start seeing, did they do DNA, for example, or did they do any type of a handwriting or any type of analysis or of blood or anything. And if it's not there, that may be important. The fact that it isn't there. Sometimes what's the most important thing in the evidence is what isn't there as opposed to what is there. Okay. So you have to go through it, and you have to go through it not one time, but you have to go through it several times. And you have to start matching up. For example, if one witness says something, the next witness you've got to see, are they consistent with the other witness, or are there changes? And if there's another witness, you've got to start matching all these up and trying to start finding out where the flaws are in the case.
Well, let's switch gears though.
Okay.
I know your practice because we're partners. I know roughly 80% of what you do is criminal defense.
Right.
What about if it's a personal injury case, or if you're litigating a business dispute? How would that differ?
All right. Well, the difference is you may not have quite the amount of evidence that you have in some of the criminal cases, but if it's a civil case, okay, I start with the client, just like we talked about a minute ago. I take a look at what they do, what they say happened, what the other person did. Then you start gathering information to see what's there, what isn't there. So, for example, let's go next. Wreck case, wreck report, a police report of what happened, or the if a death ensued from that, you're looking at a traffic homicide report from either probably a state trooper or a police officer that's qualified, and you want to make sure they're qualified. So you're looking at those things to see if they match up what they're saying, and to see if, for example, the diagrams that are drawn by the cop, are they accurate? And then you're trying to see, is the evidence supporting you from these reports, or is it against you? And if it's against you, then you've got to find out in the reports or through evidence that you're receiving through depositions. Okay. In civil cases, you get to do depositions and talk to witnesses and get them on, under oath. So you're able to then determine whether or not, how your case is.
For our viewers that don't know what a deposition is, it's sworn testimony. You're not in a courtroom, usually in an attorney's office. You can have a deposition in a courtroom, but you give a sworn statement of testimony to the parties, their attorneys, where you basically tell what happens, and it's under oath, and it can be used at trial.
Yeah, most of the time, well, I won't say most of the time, but a lot of the time, a deposition is basically a cross-examination of the other person, because the other party is probably against you. Sometimes you are taking depositions. For example, you want to find out about the injuries in a civil case. So you're going to go to the doctor they went to, and you're going to take their deposition. You're going to find out how bad the damages are to the how bad they were injured. So these type of things, have to be gathered first. You have to gather all the information. Now, this is what I try to tell people about doing a case. It's similar to me to a football. Okay. The first thing they do on Sunday afternoons, unfortunately, is they get film of the other team. And what they're looking for is they're looking for two things, just like we talked about in preparing for a case. A football coach is looking for the strengths of the other team, both offensive and defensive, and they're looking for the weaknesses offensively and defensively, because that will set up your game plan. Game plan. And that's where all this comes together, is once you have finished everything you have done in the way of looking at a case, figuring out a case, what is the issue? What do you need to do in order to win the case? Then you set up a game plan. That game plan is the key to how you go winning a case, because the way you do cross-examination in a trial, the way you put on evidence in a trial is all headed toward that game plan.
Well, Jim, I got two questions for you.
Okay.
And I'm going to go first with a game plan.
Okay.
I like to do focus groups in cases, especially bigger cases. I've done them in murder cases. I've done them in some personal injury trials or before trial when I've got
you're talking about bringing people in that are jurors. Yeah. They hear the case and you listen to them talk.
Yeah.
Yeah. Well, I've done that.
Okay. Are you a supporter of focus groups? And also, when you're drawing up your game plan, how do you do it? Do you do it based on a focus group, or are you an old school guy that kind of brings out an old whiteboard and starts sketching out, this is what we see, here's our X's and O's like a coach, these are their strengths, these are the weaknesses, this is what we're going to bring out that's our strengths, and this is what we're going to attack? Okay. How do you do it, Jim?
All right, I do it both ways. I love the whiteboard. I love drawing all the lines. Yeah. It looks like a weather map when you get through. But the focus group, here's the key to that. And this is the sad part about trying cases, in my opinion. Sometimes clients don't have the money.
That's true.
To pay for a focus group or a jurors to come in and listen to the case and you to do that. They just don't have the money. They're not available to do that. Would I like to do that in every case? Absolutely. Yeah. Now, the same goes for hiring a jury consultant. You know, that they've got a TV show about a jury consultant, you know, and he comes in and looks at, and I've done that several times. But again, you know, unfortunately, it's limited to those people that have the resources, the financial resources, in order to pay for that. Because if you do, yes, I use it. Absolutely. I still believe in the old school, as you say, the old whiteboard school that I'm coming from. I still believe in striking juries from what I see and what my heart and what my brain tells me.
I am big on that as well.
Okay. I mean, I just like to see them. I like to see what they are. Now, focus groups and jury consultants can help you sometimes go to what you're looking for. All right. The kind of juror you're looking for. And, you know, there's so many categories of people on juries, but that goes into also your game plan. Your game plan will fix for you what kind of jury you want, a juror that you want on the jury. So is it going to be old? Is it going to be male? Is it going to be young? Is it going to be white, black, green, yellow? What are you looking for? And that's what you've got to do. And that's where the game plan fits in. But picking a jury, that generally comes at the end when I've got the game plan in action, when I know what I'm going to do, when I know where I want the evidence to go, and where I know where I want the witnesses to go with me. So once I do that, I kind of have a pretty good idea of what kind of jury I want.
I had one time we focus grouped. It was an injury case, and it was what we considered a bigger injury. So of course, in those contingency fees, we front the expense for it. But we thought the whole time we had a very attractive female defendant. Sideswiped our guy. He was on a motorcycle, got seriously injured. We kept thinking we wanted female jurors, just based on some of the other facts of the case.
Nah.
focus group went the other way. I was like,
Yes, sir.
Well,
I can tell you
sometimes
that
you got
right
to think too.
offhand.
If you have a fairly attractive female or male defendant, is the opposite sex going to be more sympathetic to them?
Well, we're talking about juries. We've gone for preparation to juries now, which is okay. Yeah. But what I found, and you have to be careful about, is women jurors are more critical of women plaintiffs, defendants, or people testifying.
And that's what my initial thought was, because you see, we were representing the plaintiff in that case.
Yeah, but you got to be careful because they become a little critical about what they look like, what they say, how they react, what they do. So you've got to be careful about that. And that's a tough one. A lot of people too, and I'll tell you a misnomer also is, and this is hilarious. I had a case one time and I got down to the last strike. And I was real young. I was young. And I had a African-American defendant. But it came down to two jurors. Which one did I want? And it came down between an African-American and a white juror. So my client, who's African-American, goes, I want you to take the black juror. And I went, but I don't really like the African-American juror as much as I like the white one. But I made a mistake. I was young. I took the African-American. He ended up being foreman of the jury and wanted to hang my client. So you've got to be very, very careful about trying to use generalities about people. And, if you've got a bald client, you're thinking, well, if I get all bald men on there, I'm going to win. That's not necessarily the case. It doesn't work like that.
Because in your mind, you're thinking, oh, bald guy relates to bald.
Yeah, they're going to relate to the person, but that's not what you're after. You've got to get deeper than that. You've got to find out more about them than that. And that, of course, goes with preparation, looking online, checking all of their
social media,
what they're saying, how they say it, what their likes are, what their dislikes are, and then paying attention. You got to pay attention when you're picking a jury. And you've got to use the old body language thing some to see. You can tell. It's obvious. Jurors will tell you a lot about themselves without saying a word if you pay attention to
them. Well, you said we're getting too much on juries because
we did. We went from there. So, yeah,
Jim.
Yeah,
I got a question for you.
Okay.
Day of trial.
Okay.
First day. Of trial. Is there anything you do the night before, the morning of, to prepare to get in that mindset, or is it just second nature to you?
I hate to say this, but it's not necessarily the night before. It can be. I have had it done night before or the night before that. I will actually dream about the case. I will dream about opening, cross-examination. It's almost like it's really happening. And I get to see how the people react on the stand we know who they're going to be, but I get to see how they react. And so really, when I wake up, I'm like, okay, all right. I like that. I like how that went, or no, I didn't like how that part of it went. And I can change it up. But mainly the night before, most of the time I spend probably not sleeping, but thinking about the next day and making sure I've got opening ready and make sure I've got this ready. But I don't go in and oh my gosh, I got a case tomorrow. I better take something, calm me down. I don't think I can get through. I think I'm gonna throw up during opening. No, it's not gonna happen.
I'm the opposite. I like to get hyped up before opening.
Yeah. What is this that you've got on? Tell me what is this? What is that?
This is a
American Nightmare.
American Nightmare.
Is that you? Are you the American Nightmare?
So this is Cody Rhodes, who is the son of the professional wrestler Dusty Rhodes, the American Dream.
I do remember the American Dream.
And what I like to do to get prepared before the first day of a big trial, the morning of, I come into office, I do a quick review of my material, my notes for my opening statement and everything, some questions I want to ask jurors and voir dire. And then there's an old promo called Hard Times, the Dusty Rhodes cut. And I will watch that promo on YouTube just to get me hyped up. Gets me in the mood. And,
get you ready for the match.
It gets me ready for the fight, the courtroom battle that's about to ensue. Because, my opening statement, that's just like me cutting a promo.
Well, people, I don't know if people realize it or not, but trying cases is a lot like wrestling, if you think about it. It's man against person. Defense lawyer versus a civil lawyer plaintiff versus defense lawyer plaintiff. It's
mano y mano.
That's the only place left in America that really it exists. Okay, because a lot of times in civil cases you're able to take depositions. A lot of states like Alabama does not have that for criminal cases, so you don't know everything. You've got to be ready to respond on the spot. And I like that. I like that challenge. And you've got to be able to do that in the middle of a trial. Not change your tactics, not change where you're going, not change your theory of the case, but be able to adapt to what comes up to fit into the theory.
Well, for young lawyers that may be watching this, and just other people that may be watching, you're one of the best cross examinations I've ever seen.
Well, I appreciate that.
Tried cases against you, watched you try cases. We still haven't tried one together. We've been in business for a year and we haven't actually tried one together. We've done motion hearings together.
That's because you're chicken. You won't ever you won't ever join me in a case. You always run off with some kind of excuse, medical excuse or something.
I did herniate a disc a few weeks ago. So if you see me squirming, so you got a witness. This can be a criminal case, someone there's very limited information to file on, or it could be a civil case. They could be a rebuttal witness. Maybe someone that didn't get deposed because you took 10 depositions, someone you thought was minor, and they start testifying and you have to cross them. Is there anything you do before, or how do you prepare for a cross-examination like that on the spot? What
listen
do you do?
On the spot. Listen to what they're saying. It's got to, for them to be testifying has to relate to the case. So first of all, you've already had some testimony somewhere, or you're going to have testimony about the case from other witnesses. So listen to what they're saying. See if they're contradicting what someone else said. See if they contradict themselves. Most people think, and maybe some other lawyers will tell you I'm wrong, but most people think, and you'll hear lay people who get on the stand go, that lawyer tore me up. That lawyer tore me up. No, that isn't how it happens. You generally tear yourself up. You get up there and you say things that are just not right, that are just wrong, that sound crazy. And then a good lawyer picks up on that and heads that way. Okay. Now, the key to this, to a good cross-examination is what Ernest Hemingway wrote, in a book. Bullfight. You don't run out there and stab the bull right off the bat and kill it. If you think about it, right or wrong, whether you like it or not, a matador plays with the bull for a while, gets the crowd into it, waiting for that last moment. Is the bull going to kill him, or is he at the end going to kill the bull? That's the excitement. So you've got to toy with the witness a little bit. Don't strike hard right off the bat. Wait to the end, and then, bam, take him down.
Is there a way you would start off that cross-examination on a witness? I'll give you a hypothetical.
Okay. All right.
Let's say we've got a civil case.
Okay. Civil.
Let's say we're in a car wreck. We deposed witnesses Thursday before trial, The other side says, we'll say we're representing the plaintiff. Defense says, hey, we found out about this other eyewitness at the scene. We do a motion in limine, try to keep them from testifying because they haven't been deposed, but they get to testify. And now this witness contradicts every other witness, says our client ran a red light where everybody else says the defendant did. How would you start off with a cross-examination on that witness?
Well, first of all, I can't answer it with your hypothetical.
Okay.
Because you didn't give me all that they said, where they were, what time of day it is. Was it raining? Was it cloudy? Was it night? Was it this? Was there light streaks? Was that you know about that are factual in nature? You haven't told me whether what the witness actually saw. Did the witness say they saw a color of a car? Maybe the color was wrong. You didn't say that how many people they saw in the car. So what you're looking for is the things that don't add up. What you gave me is not enough information.
There we go. Now, that's what I was actually hoping you'd get into.
Yeah.
Details matter. Would you agree with that?
Details matter. They matter tremendously. Now, you got to be careful with details though, because not all details make a witness a liar or wrong. Okay. Sometimes witnesses aren't liars. They're just wrong about what they saw. I had a good experience one time. There were three of us, three guys, three lawyers. We were crossing the street together, and this brand new Corvette came by, red Corvette, white interior, and the most beautiful blonde was driving. Okay.
Okay.
Now, the first lawyer to my left, who was standing to my left, goes, "Did you see that car? That car is the most beautiful car I've ever seen." The guy next to me goes, "To heck with the car. Did you see the blonde that was sitting in there? I don't care what the car was. I don't even remember the car, but I remember her." So the key to it is you've got to understand human nature. Sometimes three people can look at the same object and come up with different analysis of what they actually saw in their brain. So you got to look at it from a witness standpoint. What are they really looking at? What are they looking for? And it's like, if you think about this, a guy's working at a convenience store. Guy walks in, pulls a gun, sticks it in his face. Okay, give me the money. Gives the money and run. So the police go in and go, "Describe the guy in detail." And he goes, "Well, it was shiny. It was silver colored. It had a black handle." No. Describe the guy. All I saw was gun barrels. That's what I saw. Because you see, they're focusing on something that's different than just an average person focusing on something that wouldn't be under that stress at that time. So you got to look at it from that standpoint too, and you got to be careful, because you don't want to jump in there and ask question of somebody like, "Well, why didn't you see the guy? Why can't you describe him?" Because all I saw was a big barrel, and it's going to make a fool out of you. So you got to be careful about things like that, and
so
make sure you hammer it down.
Let me ask you this: when you're prepping for a jury trial, you've got one. You're first up on Monday.
Yeah.
And you go with the case as soon as it comes in the door, you start working. Is there a certain time you start gearing up for the jury trial? Are you a 1 week out, 2 week out guy? Or are you the weekend before you go back in and review your file again? How much that prior to it do you dedicate solely to that case? Are you a guy that's got to walk away? Do you bring in your staff? What's your thought process on it?
Most of the time I do ask other people, staff, about what they think, but generally I start a couple of weeks out. I don't wait until the last minute, and I'm trying to get a fixation on not just on a juror, but what the panel looks like once you get them there. Mm-hmm. How does the whole picture look? Not just part of the puzzle, but the entire puzzle now that you put it together. What does a jury look like? Does it look like something that you're proud to have? Or is it one of those that you go, "Oh no, this ain't working"?
I agree. And especially you're working on a case from the second it walks in the door. And you've got other cases going, so you got to put it down, but you're almost constantly refreshing yourself. And then usually for me, whether it's a criminal or civil case, because civil, you'll have a scheduling order with some deadlines. Like if you get a doctor's deposition is going to be played in court versus him testifying live, where you got to get that ready and submit it a couple weeks beforehand. So whether it's criminal or civil, it seems like usually 2-3 weeks out is when I really gear up for trial, and we get the client in there preparing, going over documents, so they're ready. They know what to expect. If it's a criminal case, for example, you could have like a murder. You go over lesser included with them. Could they be found guilty of a lesser offense of manslaughter, a criminally negligent homicide, the myriad of other things? But And then I've just got, like I said, my own routine. Depending on the client, I think prayer could be important. Some clients are religious. I know I'm religious. You are as well, Christian. Sometimes I pray with clients. And then just other things. When it comes down to a trial day, I like to review everything one more time, go over my opening. I like to play my Dusty Rhodes video to get psyched up. And then after night one, the longest trial I've actually ever had was about a week. But every night I'm going over notes saying, okay, this is who's next.
Yeah.
This witness is next. We got to go through it, make sure we're ready for that all the way up until the trial's over. Now, you've done one that lasted several months before.
5 to 6 months.
And I don't know how do you live that, Jim? Is it constant preparation and continuous?
Can I tell you something? Oh, yeah. Every night you're getting ready because the judge will have an order about telling each party who the witnesses are going to be the next day for whichever party's up. Okay. So you have a list of who's coming up. So the night before, you go back and you start your homework. Okay. You start prepping for those. Now, you've already prepped for those witnesses if you've done your homework and done it like, we have done it like we said to you, in preparation of the trial. But you go back and start looking and thinking, making sure you're covering everything based on what now you've heard in court. Okay. So you're just simply matching up, checking, making sure you're ready to go the next day with that witness. So it's really, I hate to say this, but other than kind of getting tired sometimes, being in trial every day, it's really easier because you're putting aside, you have to put aside everything else that's going on in the office.
You're correct.
That goes by the way. You cannot go back and start running an office at night in the middle of a trial because you've got homework you've got to do.
It doesn't matter if it's a 2-month trial or a 2-day trial.
It doesn't matter. If it's a week-long trial, you can't every night go back to the office and start doing your office work because your mind now is getting away from what's happening with the trial. And I believe that when I go to trial, I believe I owe total devotion to that client.
And I agree with that 100%. I've told other clients that, and I always say, hey, when your case is up for trial,
with total devotion to you, brother.
The same devotion. So
yes, sir. Yes, sir. And you can't get sidetracked with something else that's going on in the office, and then next thing you know, here you are, and you're doing more with the office than you are doing with the trial because the trial is what's important at that time. That's where you are. So you have to be ready and be moving. One thing that I really enjoy, now the trial that went 5.5, 6 months was a one-person trial, one defendant. That makes it harder. If you have several defendants and it's going that long, it's really easier than you expect because the other people go and do cross-examination, and some witnesses you may not need to do it with, and you let them go. So you kind of sit there and kind of relax a little bit. You're not on edge all the time and having to think, I'm up next.
Who was that one defendant that lasted 5-6 months for trial?
That was the Scrushy case out of Birmingham in federal court.
Okay. For our viewers that haven't watched your Netflix documentary.
Yeah.
Well, what was the Scrushy case? Who was Scrushy?
He was the CEO of a very large corporation at the time called Health South, and he was indicted for fraud with regards to the corporation. And it was probably one of the largest, if not, I don't know if people keep talking about, I don't know if this was a $3.5 billion fraud. So I don't know if anything bigger than that in money wise.
Maybe the only thing, maybe just now we might have something rivaling it, and that would be, what is it, FTX?
They just indicted the guy from the Bahamas and brought him back.
Sam Bankman-Fried.
Yes. Yeah. Now I looked at that, but they're only saying, some of it's only like a billion or $1.2 billion. So I don't know. I don't know what the total figures are going to be because he did the fraud that I read about, and I'm not saying he's guilty at all. I'm just saying what you read in the paper. And by the way, folks, you have to be careful of that. But what I read, indicated several ways he went about the fraud. So how much is involved? are they going to charge him individually with different counts of different ways of committing it, or are they going to do it all? I don't know.
So I'm reading a news article right
Yeah.
now on ABC News, says the value of XTX as recently as January was 32 billion, but that's the entire company.
Yeah, see, that's not what I'm talking about.
Yeah.
The Health South was an actual dollar figure fraud of like 3 billion, 3.5 billion, whatever it was. And so that's not the value of the business. That's what was actually involved in the fraud itself. So
correct me if I'm wrong, but was Richard Scrushy the only person ever indicted under the Sarbanes-Oxley Act?
No, there were 5 or 6 more. They all pled guilty, and
he was the only one that went to trial, though.
He was the only one that went to trial.
Did they charge anyone after him? Do you know?
I think that ended it. I don't know of anyone right offhand that I recall that after the fact. He was the CEO. He was the head of the head of the game. He was the head of the whole business. And so I think that's where it stopped, was with him. By then they had everybody.
So preparation and good trial work by you and Donald Watkins changed government policy.
Well, it did in some respect. It sure did, because, I won't get into the explaining it, but the Sarbanes-Oxley Act, they passed because of corporate fraud in America. And that was the only trial they've ever used it in. And of course, the reason they used it was because the penalties under the Sarbanes-Oxley Act were so high. You spend a whole bunch more time in prison under that. But it changed how they did accounting and how they did the books with the corporation. But Richard was found not guilty of all of that, and thank goodness.
So Jim, we've talked about pro wrestling legends.
Pro wrestling, yes.
We talked about gearing up for trial and some of the things we do to prepare.
We have.
Would you compare prepping for trial to the way a fighter engages in like a training camp before a fight, where they take a few weeks?
Yeah, I think it would be. I think any sport, and I'm not talking about law being a sport. It's a very serious matter, but to a boxer, it's serious too, because he doesn't want to get the heck beat out of him. But yeah, because he's trying to figure out, what is the strong part? What are the weak part of his opponents? What does he need to do? Does he move more in the ring? Does he stand still? Does he approach? Does the other guy come into him, or does he go into him? Does he keep off the ropes or go to the ropes? And, it's the same thing. You have to prepare for whatever you're going to do in life. Okay. It's just not, you just don't step out and just go do it, and, the next thing that I think is important is you can prepare, but now you've got to perform.
That's right.
It's not that way. I heard, and I am so sorry to hear about Mike Leach, the coach. For those of you who don't know, he was a coach at Mississippi State, quite an innovator, quite a character, a great guy. And, he passed away, but I heard him say it on the radio one time. And he said, a lot of players prepare for the next game during the week, but when the game gets here, they just don't want to really play. Mm-hmm. So it's not just preparation that's going to get you a victory or get you what you want. You've got to now go out and take that preparation, put it into action, and perform and get it done.
That's a good quote, Jim.
Yeah.
Well,
I tell you what, let's do. I know we're about through for today. Okay.
Let me
because that sweater you've got on is killing me, and I'm cross-eyed now with looking at it. But why don't you tell them, what we got coming up?
Okay,
what have you got for me?
Let me tell everybody what's coming up. Well, we talked about preparation and how it's important.
Yeah.
We're going to continue to improve the podcast. Episode 1's up. We're working on getting video editors. We may get some sponsors, but we have our first celebrity guest coming up, who I will leave as a surprise. But I will say this: we've talked about fight camp and how people prepare. Let's find out how a fighter prepares. We will have a former world champion as a guest, a world champion fighter.
Wow.
So if people want to find out who that is, they need to stay tuned and tune in for the next episode.
Wow. Absolutely. Yeah. And I think we have some some other celebrity guests coming up in the
We got
future.
a few more lined up.
Yeah, different genres, right?
Yes,
That
we got
they're
some
in.
athletes, some musicians,
Athletes and maybe some
some actors,
musicians,
yeah,
stuff like that, you know?
and a few other trial attorneys.
Oh, wow. That would be great because I'm always learning. I always said the day I quit learning is the day I quit this job.
Yeah. So,
Well, it's been good. You know, American Nightmare. You know, maybe I
hashtag
need to
Cody
get me
Rhodes.
one of maybe I need to get me one of them sweaters, you know, and wear.
I'll get you one for Christmas.
Thank you, buddy.
All right.
Good to see you. See you next time.
All right.